Hi, my name is Peter Renn, and I'm a staff attorney at Lambda Legal. The Ninth Circuit Court of Appeals issued a ruling today in Perry v. Schwarzenegger, which is the federal constitutional challenge to Prop 8. Although the court hasn't yet ruled on the larger question of whether Prop 8 is or is not constitutional, it did do two important things. First, the court said that in order to even entertain the question about whether Prop 8 is constitutional, the proponents of Prop 8 will need to show that they have a unique interest that distinguishes them from the millions of other voters who voted in favor of the initiative, and that this issue is best decided by the California Supreme Court. The reason is because whether the proponents have that special type of interest turns in part on California law. Because the California Supreme Court generally has the last word on what state law means, the federal court has essentially punted the question over to the state court for it to answer in the first place. The second important thing that the court did today was to hold that whatever specialized interest proponents of an initiative may or may not have in defending a law, it's crystal clear that counties don't have it, let alone deputy county clerks, just by virtue of the fact that they issue marriage licenses. And yet that's precisely who was trying to intervene also in the case here, not even the county clerk, but just the clerk's underling. The court held that these tangential interests aren't going to be enough to keep the lawsuit alive. So that, in a nutshell, is what the court did. Although there isn't a deadline by which the California Supreme Court has to respond, it's likely we'll hear from them in the next few months, and from the Federal Ninth Circuit Court of Appeals thereafter. If you'd like to see more information, you can visit our website at lambdalegal.org.